Okay, so if you work in Ontario, I want you to listen up. Because that job contract you signed, it might just be a ticking time bomb. A whole bunch of legal changes in 2025 have thrown a major wrench into what we all thought we knew about our rights at work, especially when a job ends. So let's get into it and figure out what this all means for you.
And I'm serious, just take a second to think about that. That piece of paper you signed maybe years ago when you started your job, is it actually enforceable today? The answer might genuinely shock you, especially with all the legal shakeups we saw last year.
So here's how we're going to break it down. We're going to walk through the whole journey, right? From starting a new job to the day-to-day rules, what happens when you need to take time off, and then the really high-stakes stuff, what happens when employment ends. And to wrap it all up, we'll look at a new way people are getting legal help in this kind of confusing landscape.
Let's start right at the beginning, shall we? The first chapter, the day you get hired. Believe it or not, some pretty big changes now affect you from the moment you say yes to the job. Here's the first big one. A brand new rule kicked in on July 1st, 2025. That changes things right from the get-go. Your employer is now legally required to give you all this basic info in writing. We're talking their proper legal name, where you'll work, exactly what you're being paid, and when you'll get paid. No more guesswork. It's all about making things crystal clear from day one.
So where does all this come from? Well, it's all part of Ontario's Employment Standards Act, or what everyone calls the ESA. The best way to think about the ESA is that it's the absolute floor for your rights at work. It's the minimum standard that no contract or employer can legally go below. It's the baseline.
Okay, so with that foundation in place, let's look at how these rules actually play out in your day-to-day work life, the everyday essentials.
You know, the ESA lays out some really clear boundaries. For most jobs, you can't be required to work more than 8 hours a day or 48 hours a week. And that overtime pay, it kicks in after you hit 44 hours a week, and it has to be paid at time and a half. Oh, and that 30-minute meal break for every 5 straight hours of work? That's not just a nice gesture, it's the law. These are the core rules of the road.
And speaking of pay, here's a number that made a huge difference for over 800,000 workers. As of October 1st, 2025, Ontario's general minimum wage went up to $17.60 an hour. This is a perfect example of how the ESA steps in to set that baseline for everybody.
Okay, but let's be real. Work isn't everything. Life happens, right? So let's talk about how the law protects your job when you need to step away for a bit.
This was a huge change that came in June of 2025. Ontario now has something called a long-term illness leave. It means if you have a serious medical condition, you can take up to 27 weeks off to recover. Now, it's unpaid, but it is job protected, which is the key part. It means your job has to be there for you when you get back. All you need is a note from a doctor or another medical professional to qualify.
And now, we get to the climax of the story. This is where the fine print in your contract becomes absolutely critically important. The day your employment ends.
Remember how we said the ESA is the floor? Well, this right here is what that floor looks like for termination notice. It shows the absolute minimum notice, or pay in lieu of notice, that your employer has to give you if they let you go without cause. It goes up with how long you've worked there, topping out at 8 weeks for 8 or more years of service. This is the legal safety net.
But here's where things get really tricky, and it's why so many contracts are suddenly up in the air. The courts have this idea you can call the one bad apple principle. Basically, if even one tiny part of your contract's termination clause breaks the rules of the ESA, it can spoil the whole bunch, making that entire section of your contract totally unenforceable.
And this one principle led to an absolute legal showdown in 2025. I mean, just look at this. You had 2 different courts looking at very, very similar contract wording, and they came to completely opposite decisions. In one case, Baker, the clause gets thrown out. But in another case, Lee, an almost identical clause was found to be perfectly fine. This just created a massive cloud of uncertainty for everyone.
So what was all the fuss about? Well, the whole argument that caused all this chaos came down to 2 little words: at any time. In the Baker case, the court said that phrase is just too broad. It could, in theory, cover illegal situations, like firing someone while they're on a protected leave. And since the ESA doesn't allow termination literally at any time, that one phrase was enough to invalidate the whole clause.
So you can see how this set up a major legal cliffhanger. We had these conflicting rulings in 2025, and now
The entire province is basically holding its breath, waiting for March 2026. That's when the Ontario Court of Appeal is scheduled to hear both cases and finally give us a clear, final answer. The decision they make is going to be a true game changer for so many people.
So with all this confusion and these legal battles, how is an ordinary person supposed to navigate their rights? Well, this complexity is actually helping push forward a new and honestly more accessible way to get legal help.
Let me introduce you to this idea called unbundled legal services. Think of it like legal services a la carte. Instead of hiring a lawyer for your entire case from start to finish, which, as we know, can cost a fortune, you hire them for just one or two specific tasks, and you handle the rest yourself. Here's how it actually works in practice. First, your legal problem gets broken down into smaller pieces. Then, you get to pick and choose what you need help with. Maybe you just need a lawyer to review your termination letter or to give you an hour of strategic advice. The lawyer does that part, often for a set fee, and you stay in the driver's seat for everything else. It's all about getting that expert help right where you need it without the massive bill.
Really, what unbundling offers is this vital middle ground. It's for people who can't afford a full-time lawyer, but know they can't just go it alone either. It's a way to empower yourself with professional legal guidance at those key moments without breaking the bank.
Which leaves us with this final thought to chew on. As employment law keeps getting more and more complicated, like a minefield of new rules and conflicting court cases, is this more flexible, do-it-with-me style of legal help the future of accessing justice? It's a pretty powerful question to think about as we all try to understand and protect our rights at work.